Welcome everyone. I'm attorney Rilus Dana. In this video, we'll be talking about prenups. Going to be talking about marriage plans. So this is going to be helpful for anyone, especially in community property states like Arizona, California, Nevada, any of the other community property states out there. What I call a marriage plan, or if you're not planning on getting married, but you're cohabitating, moving into a house together, or buying a house together, it's a good idea to, one, update your estate plan. And the second part is I recommend clarifying the relationship. So if you're planning on getting married, you might want to consider opting out of the default community property rules. Or if you're not even planning on getting married, your partner may gain some interest if you're living in a property together. Cohabitation agreement, something to consider. All right, so here's what we're going to do in this video. So first, we're going to talk about the community property rules. We're going to define what that is and what it means. And then we're going to talk about how to clarify or opt out of those default rules with the premarital agreement. That's also known as the prenup. And then we'll talk about estate planning options for couples that are bringing assets into a marriage. Here's our friends here, Mr. and Mrs. Estate. What is community property? A basic definition is it's all property acquired during the marriage, except for gifts. Let's look at some examples here. Mr. Estate here has a bank account and a house, a separate property. He meets the soon-to-be Mrs. Estate. She has her own bank account and retirement account. They get married, then the community is created. So once they're married, they no longer exist, is how I explain this. Everything belongs to the community together. They go to work, receive income from his job. If he puts this money into a separate bank account, is that his separate property? No, it's not. He doesn't exist anymore. Even though he's going to work, he's working for the community. Even though that money goes into a separate bank account, or this bank account that is titled in his name, it's not separate property. The community has an interest. Now, how about if she puts money from her job into her IRA, her retirement account? What happens there? So same thing. The community is gaining an interest. It's not her going to work, the community is going to work. The income earned during the marriage is community property. If they bought a house together, that'd be community property. What if he has a house before marriage? Let's say Mr. Estate over here has a house, and that IOU piggy bank, that's his mortgage. So the mortgage is in his name and the house is in his name. They get married and he takes the money from his job and pays the mortgage on this house that he had before marriage. So what happens? The community is now gaining an interest in that property because the community is paying that mortgage. It's complicated. It gains an interest based on how much principal is reduced. Now, how about inheritances? So Mr. Estate, his parents pass away, they have a trust. If Mr. Estate takes his inheritance and puts it into a community property account, he's made it community property. But if he receives his inheritance and puts it into a separate bank account or creates a new bank account where it's easily traceable that this money was from his inheritance, then that remains his separate property. It's all property acquired by either husband or wife during the marriage is the community property of the husband and wife, except if it's acquired by gift, devise, or descent, or acquired after service of petition for dissolution of marriage. This is Arizona, so that's a tiny bit different in California. So next, let's look at how you can clarify or possibly opt out of those rules with the premarital agreement. So the prenuptial agreement, the requirements, pre means before. So it's got to be before the wedding. Seems obvious, right? There is a thing called a postnuptial after. I'm of the opinion that postnups are not valid. It's not going to be worth the paper it's written on. There may be some reasons to do it, but I don't think it's going to give you as much protection, or if any protection. The main reason why it's important to do it before marriage is because that's the consideration of the deal. The two parties are coming together in consideration of marriage. If there's already a marriage, then what is the consideration for the contract? And then the other requirement is that it's got to be understood by both parties. So that means enough time. It's got to be in their native language, and really it's got to be represented by a lawyer. How can you prove that they understood the agreement unless they were represented by a lawyer? All right, so some common mistakes that make prenups unenforceable: less than full financial disclosure by one or both parties. Another part of these agreements is there has to be full disclosure. You have to make each party aware of what they're getting into. If it includes provisions that are blatantly unfair to one party, that's going to be thrown out. Or if the other party did not have the opportunity to consult an attorney. If it was signed in a very short time period, like on the way to the wedding, as an example. Or if there's any duress or coercion, it's not going to be valid. If you're not getting married, you don't have those default community property rules, but there could be some rights based on contract theory. In California, they call it a Marvin action. Now let's look at some estate planning options. I love meeting with couples getting married or moving in together. We get to be a little bit creative and look at different ways to best protect both parties. So I want to review a couple terms. The deed is the way that you show the ownership of real estate. And then debt, oftentimes you buy a house, you borrow some money with a mortgage, and that's a secured debt on the property. So there could be a second or other liens. But I just want to separate this idea of the deed and the ownership and the debt. All right, so couple here, they're going to get married. They each have kids from a prior relationship, and they each have some assets. So this example, they're each going to create their own single trust. So they'll be the boss of it, the trustor, the trustee manager, and the beneficiary. Unlocked, meaning revocable. They'll name their successor trustees, their beneficiaries, and they'll determine when and how their beneficiaries receive it. Okay, so what they can do with real estate, so if they bought a house together, or if they both have ownership into it, they can split that house up and put a piece of it in both of their trusts. A lot of times we do this based on what each party paid for it. So it's not always 50-50, but we can separate the ownership. And then all of their assets go into their trust. Now, IRAs and life insurance generally stays out of the trust because you name beneficiaries. So we don't worry about putting that in. Now, in their trust, they can designate either their kids to be the beneficiary or their partner. And same thing with the IRA. So this example is showing a life estate in the property. Here's what that looks like. So he passes away. His trust named his successor trustee. His trust is going to distribute to his children, except for his share of the house. So it looks like the IRA goes to his spouse, and his share of the house, it stays in his trust. And this life estate says that she can live in his share of the house for the rest of her life. So that's what the life estate means. It's reserved in this trust. It makes it clear that the kids down here, that they can't move into the house. They can't force her to sell it. They can't rent out the other rooms on Airbnb. So this gives her good security that she can live there as long as she wants. Now, if she ever decides to sell the house, then the remainder would go to the kids, or when she passes away. So if she passes away, then the remainder goes out to his kids, and then her trust goes to her children. So couples looking to get married, you can come in, see me, we'll talk about estate planning. Let me bring up the prenup. It's a hard thing to bring up. It can be an uncomfortable topic, uncomfortable conversation. But I think if you start with protecting your partner, you'll start with your estate plan and how you want to protect them if you were to pass away, we can look at to see if it makes sense to opt out of those default rules, especially if you have your own business or separate property like real estate where there's still mortgages in place. That can get complicated. Complicated in the sense if the relationship were to end in divorce, it'd be really easy for attorneys to come in and make different arguments. So the goal of the prenup, the premarital agreement, cohabitation agreement, it's really just to clarify together while you're still in love of how things would work if the relationship ended. So who's bringing what into the relationship? And if the relationship ends, who takes what out of it? Now, in my world of estate planning, usually relationships end upon death, but in the world of family law, they could end upon divorce as well too. So that's what makes me suited to help people plan for this area, because usually I'm planning for relationships ending upon death. Hope you found this helpful. Let me know what you'd like to hear about in the next video. We'll see you next time.